Your parents did the responsible thing. They sat down, maybe with a lawyer, maybe at the kitchen table, and they wrote a will. And in that will, the family home goes to you. They told you about it with a kind of relief in their voice, because as far as they know, the house is handled. It's taken care of. You'll be fine. Here's what nobody told them. A will does not hand you the house. It hands the house to a court. That's what a will actually is. Not a shortcut around the legal system, but a set of instructions for it. And when your parents are gone, before you can sell that house, or move into it, or even stop paying to keep the lights on, it has to go through a process called probate. For a house, that process routinely takes a year, sometimes closer to 2, and it costs money the whole way through. So the very document your parents signed to protect the family home is the thing that locks it in court for months. Now, I don't want you scared of this, I want you ahead of it, because a house can be lifted completely out of probate with something as small as a one-page deed. But first you have to understand why the will, all by itself, quietly guarantees the opposite. The whole trap lives in the space between two things that sound identical but are worlds apart: inheriting a house and inheriting a court case. Let me walk your family through both. Start with your parents. In their minds, the story is simple and complete. They own a home, they love you, they wrote it down, the home is yours. They feel finished, and they feel generous, and both of those feelings are earned. Nobody at that table is imagining a courtroom, because a will is supposed to be the thing that keeps you out of one. Now stand where you'll actually be standing. Your parents are gone, the house is legally promised to you, but it is frozen. You cannot sell it because you don't hold clear title yet. You cannot refinance it. In many cases, you can't even list it. And the entire time it sits there in limbo. The mortgage is still due, the property taxes are still due, the insurance and the heat and the lawn and the leaking roof are all still due, and now they're due from you. Do that arithmetic on your parents' actual house. Whatever the mortgage, the taxes, the insurance, and the heat come to in 1 month, multiply it by 18. That is the number that arrives with the house, and it arrives before you are allowed to sell it, move into it, or hand back a single key, for a year, maybe 2. On a house you own on paper and can't do a thing with. That's the two-body cruelty of it. Your parents hand you what they believe is a home, a gift, a soft landing. And because of one gap nobody flagged, what actually lands in your lap is a bill with a lock on it, and a court date somewhere down the line that finally, slowly, lets you have the thing that was always supposed to be yours. So why does a house do this, when the money in your parents' bank account often doesn't? Because a house is the one thing they own that cannot quietly change hands. A car has a title office. An account can have a beneficiary line. A house has a deed, and a deed needs somebody with authority to say who signs it next. And once your parents are gone, the only body with that authority is a court. That process is called probate, and it's much less mysterious and much more expensive than people think. A judge confirms the will is real, debts and taxes get settled, and only then does the court authorize the assets to move to the people named. And here's the key: anything that passes through the will has to go through probate to get there. The will doesn't move your house. It asks a court to move your house, and then everyone waits for the court. For a family home, that wait is the problem. Probate commonly runs 12 to 18 months, and for anything complicated, it can stretch toward 2 years. During that stretch, the house is stuck in the estate. It can't cleanly change hands, and it isn't free to sit there because probate has its own costs layered on top: court filing fees, attorney fees, executor fees, appraisals. Depending on the state, those can eat a real slice of what the house was worth, money that was supposed to be your inheritance, spent instead on the process of unlocking your inheritance. And there's a quieter cost most people never picture. Probate is public. The will, the value of the house, who inherits what, all of it becomes an open court record that anyone can look up. That's often where a calm family turns tense, because now there's a court, a clock, and a frozen house for everyone to have an opinion about. If you have siblings, probate is where estates crack. A home that could have passed quietly in an afternoon instead spends a year as a matter of public record and shared frustration, and sometimes as an outright fight nobody wanted. And now the misconception that traps good, organized families, the ones who did their homework. Most people believe that having a will means you avoid probate. It is exactly backwards. A will is the instruction sheet that probate reads. If the only plan for the house is, it's in the will, then the house is, by definition, going to court. The families who skip probate on their home didn't do it with a better will. They did it with a completely separate tool aimed specifically at the house that moves the property outside the will altogether. That tool is the whole back half of this video, and it's simpler than the will your parents already wrote. Arthur and Helen were the couple every family wishes it had. Organized, careful, done with their paperwork years early. They had a will drawn up by a real attorney. It left their paid-off house to their son Mark, and they mentioned it to him more than once, with pride, so he'd never have to wonder. As far as all three of them were concerned, the house was settled. When Arthur and Helen passed within a year of each other, Mark found out what settled actually meant. The house went into probate, and it stayed there for 14 months. For 14 months, Mark paid the property taxes on an empty home he couldn't sell. He paid the insurance because letting it lapse on a vacant house would have been a disaster. He drove over to check the pipes in winter. And he watched attorney and court fees quietly draw down the value of the very thing his parents had worked their whole lives to leave him clean. What stuck with Mark wasn't anger, because there was no one to be angry at. His parents had done more planning than most people ever do. They'd hired a professional, they'd put it in writing, they'd told him. They had simply never been told that the one document they trusted to protect the house was the document that guaranteed it a year in court. The gap wasn't in their effort, it was in the single fact nobody handed them. And that fact is the whole reason a one-page deed exists. Arthur and Helen could have kept that house out of probate entirely for a couple $100, with a form neither of them had ever heard of. So let's make sure you've heard of it. This is the Shield. Here's the genuinely reassuring part, and it's a relief after all that. A house can be lifted completely out of probate, and it usually doesn't take a lawyer's retainer or a complicated plan. 3 moves. Move 1. Understand that the house needs its own probate avoidance tool, separate from the will. This is the mental switch that changes everything. Stop thinking we have a will so we're covered, and start asking, specifically, what moves the house outside the will? The will can stay exactly as it is for everything else. The house just needs its own path. Move 2. For a lot of families, the simplest path is a transfer on death deed, sometimes called a beneficiary deed. It's a short document your parents sign and record now, while they're alive and well, that names who gets the house the moment they pass. It changes nothing while they're living. They still own it, can sell it, can change their minds. But at death, the house transfers straight to the named person, with no probate at all. It's available in well over 30 states, and it's usually inexpensive. A handful of states, Florida, Michigan, Texas, Vermont, and West Virginia, use a close cousin called a ladybird deed that does the same job. One recorded page can save your family that entire year in court. Move 3. If the estate is larger, or there's more than just the one house, the stronger tool is a revocable living trust. Your parents create the trust and then retitle the house into it, and when they pass, the person they named, the successor trustee, can transfer the home in a matter of weeks, with no court involved. It costs more to set up than a deed, but for a bigger estate, it can be worth every dollar. And keep the will, by the way. You still want one. It just shouldn't be the house's entire defense against a year in court. Do any one of these, match to your family's situation, and the house stops being a court case waiting to happen and goes back to being what your parents meant it to be. A home, handed to you cleanly. Now the honest edges, because the right tool here depends on your state and your family, and the wrong assumption is expensive. A transfer on death deed is wonderful where it's offered, but not every state offers one, and it only works if it's properly signed and recorded before death, not left in a drawer. Whoever inherits the house also takes it with whatever is still owed on it. the mortgage, and any liens come along for the ride. A living trust avoids probate beautifully, but only if the house is actually retitled into the trust. An empty trust with the home still in your parents' own names does nothing, and that mistake is heartbreakingly common. There's also plain old joint ownership, which does skip probate. But if you saw my video on putting your name on a parent's account, you already know that road can expose the home to your creditors and problems, so it's not the casual fix it looks like. And very small estates sometimes qualify for a simplified affidavit instead of full probate. The point isn't to pick one from a video, it's to know that "it's in the will" is not a plan for the house, and to fix that with the right tool for your state. One sitting with an estate or elder law attorney in your parents' state, while your parents are alive to sign, costs a small fraction of a year of probate on a home. So go back to that moment at the kitchen table, your parents telling you with relief that the house is yours, it's all in the will. Everything about that moment is loving and well-meant, and that's exactly what makes the gap so easy to miss. The will is real, the love is real. It just quietly points the house at a courtroom instead of at you, and no one in the room can hear it happen. So here's the move, and it's a single question you can ask this week. Sit down with your parents and ask, plainly, is the house set up to skip probate, or does it just pass through the will? If the answer is some version of, "it's in the will, we're covered," you've just found the gap, gently, years before it would have found you. You're not questioning their planning, you're adding the one page it was missing. Your parents want to hand you that house clean, the way they earned it. If this video helped you close that gap for your family, hit subscribe. I put out a new one of these twice a week, and I'd rather your family fix this over a quiet weekend than discover it in a courthouse hallway. And if you know a family whose whole plan for the house is, "it's in the will," hit like, because that's the exact family this was made for. A will sends the house to court. One page can send it straight to you instead. Now you know which is which, and your family won't learn it the slow, expensive way. I'll see you in the next one.